North Carolina needs to do more to protect property owners from the threat of eminent domain abuse. That was the key theme of a column at CarolinaJournal.com. Its author is Ray Nothstine, opinion editor at CJ. And Ray, why is it that North Carolina needs to do more on this front?
Well, North Carolina is a state that hasn't reacted really to the Kelo versus New London decision, famous Supreme Court decision from 2005 that basically allowed, and I think is a violation of the Bill of Rights, but it takes the taking clause of the Fifth Amendment and allows that a private entity can basically collude with the government to take your home or your land for development purposes, whether it be for increased tax revenue, whether it be for creating infrastructure or jobs. And so that was a controversial 5-4 decision. And North Carolina is one of the few states that hasn't reacted across the country to that decision. In the wake of that decision, there were a ton of states that changed their constitution, changed state statutes to prohibit that kind of eminent domain abuse from happening.
Some people are going to look at this situation and say, this is because it's not really a problem in North Carolina. We haven't had a big issue with eminent domain abuse. Is that a good excuse?
Well, I think it's a valid point in the sense that it is off a lot of people's radars because there hasn't been that kind of abuse like we've seen in other states. But it's not an abuse, and it's not a good decision to use that excuse not to change the Constitution because we don't know in the future how that could potentially develop, what could change in the culture, especially with so many businesses coming in, with so much change in the demographics of the state and new constituents. That is something that obviously the General Assembly is going to want to address, and that I think the voters would unanimously support and approve if they had a chance to change their constitution.
This is the type of thing that has cropped up ever since that Kelo case. Bills have been filed. Sometimes I think they've even gotten through the House.
Yes.
But the General Assembly hasn't sealed the deal and put this into on the ballot for constitutional amendment to vote for the voters. What should be different this time around?
Well, I think just public awareness. If there's something that we can do here at the John Locke Foundation, like writing an opinion piece about this, raising awareness about eminent domain abuse, because it is a central issue. And I think, too, also just focus some more on that Kelo decision. Of course, there's a famous movie. I think the Institute for Justice was involved, Little Pink House. Very good film starring Catherine Keener, and it tells the story about basically how working class citizens can be removed from their land or home because of eminent domain abuse. So I think it's important to understand that we've seen in the wake of all these COVID restrictions how private property, how businesses can be destroyed, and how government can create that havoc and create that situation or scenario where that can happen. So I think just in that sense, raising awareness would be a big boon for the state. And also, you're right. I mean, I think it's passed the House of Representatives like 7, 8, or 9 times and has died in the Senate. So I think it's incumbent upon constituents to contact their lawmakers and tell them this is something they would support, a strong eminent domain reform in North Carolina and to change their constitution.
For those who don't know, the Little Pink House was owned by Suzette Kelo, who was the lead plaintiff in that famous case, infamous case perhaps. You are a person who focuses a lot of attention on fundamental rights and the importance of protecting them. If we don't take a step to protect this fundamental right of ownership of private properties, why is that a problem?
It's a huge problem. I think people should go and read the Kelo dissent by Clarence Thomas. It was a 5-4 decision again. And he lays out, and he goes through Blackstone. He goes through the property of the West. Even before the Bill of Rights, he kind of lays out why this decision was decided in the wrong manner. And I think it's important to kind of focus on those fundamental principles and getting back to what the founders envisioned. Because look, if you have a weak eminent domain amendment and it passes the House, the Senate, let's say Governor Cooper vetoes it, but they were able to override his veto, not a lot's going to change because, look, the Supreme Court has already decided that if you just say for public use, if that's the only change that you're making instead of public use and benefit like you have in North Carolina, then the Supreme Court has already ruled that this can be finagled, that you can drive a Mack truck through it. States like Virginia, Florida have much better eminent domain amendments and laws and statutes. And so I think it's important to focus on what the founders envisioned for property rights because they had a very high view of property. James Madison called it the most sacred conscience, the most sacred right of our conscience. And so I think it's just important to really understand on what the founders viewed about property and to reflect that, because they understood better than anybody how government can abuse power. And you see it in eminent domain cases quite a bit.
One nice thing about going the constitutional amendment route is Governor Cooper couldn't veto a constitutional amendment. So does that make another argument for making this a constitutional amendment to take the governor out of the equation?
Right. I think there's truth to that. I mean, I don't know ultimately if he would oppose or support something like this, especially if you had a significant number of North Carolinians support it. I know polling in the past at Civitas has put it close to 2/3, maybe a little bit higher than that. So it has broad support. I mean, people want to be treated fairly. People don't want to see government collude in a cronyist manner to take away someone's home or land, to turn it over to developers. That's not what the founders envisioned when they talked about eminent domain and the taking clause for public use. That's not at all what they envisioned. So I think obviously that would have broad support. And I would hope that, even if he didn't have the chance to veto it, Cooper could use his bully pulpit to support something like this. I mean, it should have broad bipartisan support.
The column is about eminent domain abuse and protecting North Carolina property owners against it. You can find the column at carolinajournal.com. Its author is Ray Nothstine, opinion editor at Carolina Journal. Thanks so much.
Thank you.